There is a legal test that exists inside every single medical malpractice case filed in the United States of America. It is not printed in any hospital consent form. It is not disclosed by any insurance adjuster when they make you a settlement offer. And in the vast majority of cases, it is the only thing standing between you and the compensation you are legally owed. Most injured patients have never heard of it. Most lose because they never understood it. It is called the standard of care, and it is the invisible legal line that separates a doctor who simply made a mistake from a doctor who legally committed malpractice. Those two things are not the same, and the distance between them is the difference between a documented settlement and a dismissed case. By the end of this episode, you will know exactly how this test works, who legally defines what the standard is, how it is proven in a courtroom, and the precise reason why most attorneys reject legitimate malpractice cases that arrive at their desk every single week. Because if you are ever going to walk into a legal consultation about a potential malpractice claim, you need to understand this test before that meeting, not after. Welcome to Torts and Truth. This is your decoded advocate. If this is your first time here, subscribe right now, because what follows will permanently change how you evaluate every medical decision made on your behalf. If today's episode added value, like, share, and leave a comment below. And if you have a thought or question, I want to hear it. The definition most patients never receive. Most people approach a malpractice consultation with a singular belief. The doctor made a mistake. The outcome was bad. Therefore, there is a case. That logic feels correct. It is legally insufficient. Medical malpractice has a precise legal definition, and that definition does not include the word mistake. Under American tort law, medical malpractice is the failure of a physician to meet the standard of care, defined as the level of skill, knowledge, and treatment that a reasonably competent medical professional in the same specialty would have provided under the same or similar circumstances. The operative phrase is not the worst possible outcome. The operative phrase is not the most aggressive treatment available. The operative phrase is reasonably competent, which means the law measures your physician's conduct against the average competent specialist in that same field, not the best physician in the country. The average competent one. This single distinction is the reason more than 90% of potential malpractice cases are declined by attorneys before a single motion is ever filed. The four-element test. Every gate must open. To succeed in a medical malpractice action in the United States, four legal elements must be proven sequentially with competent evidence. Duty. A formal doctor-patient relationship must have existed at the time of the alleged harm. This sounds obvious, but it carries legal weight. A physician who advises you informally at an event has not necessarily assumed a legal duty of care. The existence of a formal treatment relationship is what creates the legal obligation to provide care consistent with the accepted standard. Breach. The physician must have deviated from the accepted standard of care. This is the single most contested element in every malpractice case without exception. It is not sufficient to prove the outcome was bad. It is not sufficient to prove a different physician might have done something different. The plaintiff must demonstrate, through qualified expert testimony, that what the treating physician did or failed to do fell below what a reasonably competent physician in that specialty would have done under the exact same circumstances. This is where most cases end before they begin. Causation. Even after breach is established, it must be directly linked to the specific harm. The plaintiff must prove that but for the physician's breach, the harm would not have occurred. In cases involving pre-existing conditions, late-stage illness, or chronic disease, causation is frequently the element that silently destroys otherwise valid claims, because the defense argues the harm was inevitable regardless of the breach. Damages. The breach and causation must have produced actual, documented, quantifiable harm. Medical expenses, lost wages, permanent disability, pain and suffering, death. Without documented damages, there is no viable claim. Regardless of how clear the deviation from standard was, these four elements function as sequential legal gates. A claim that fails at any single gate cannot proceed. No exceptions, no substitutions. The expert witness requirement. Here is where the standard of care test becomes structurally difficult in a way that no other personal injury claim replicates. You cannot prove breach without a qualified medical expert who is willing to testify, under oath, in deposition, and at trial, that a colleague deviated from accepted medical standards in most states. That expert must practice in the same or a closely related specialty in many states. That expert must be actively practicing medicine, not retired. This creates what legal scholars have formally documented as the conspiracy of silence, an institutional phenomenon where physicians are systematically reluctant to testify against fellow physicians. The economic implications are severe. Qualified expert witnesses in malpractice cases cost between $5,000 and $50,000, depending on specialty, case complexity, and hours required. An attorney who takes a malpractice case on contingency must be personally confident enough in the breach, the expert availability, and the damages to invest that capital before any recovery. This financial structure alone eliminates the majority of legitimate malpractice cases from ever reaching formal litigation. Not because the patient was not harmed, but because the economics of proving standard of care breach make the case financially unviable for the attorney absorbing the risk. Locality rule versus national standard. For most of American legal history, malpractice law applied the locality rule, measuring a physician's conduct against what doctors in the same geographic community would do. This doctrine systematically protected rural physicians by effectively establishing a lower regional standard. Over the past 4 decades, most states have transitioned to a national standard, measuring physician conduct against what a reasonably competent specialist would do anywhere in the country. But the transition is not uniform. Some states retain modified locality rules. Others apply hybrid standards. And the standard applied in federal court can differ from the state standard in the same jurisdiction. This geographic variance means the same medical conduct can legally constitute malpractice in one state and fall within acceptable care in another. The state where treatment occurred determines the applicable standard, not where the patient lives and not where the attorney practices. This is a critical evaluation point that most patients and even some attorneys miss in the initial case assessment. What a valid breach actually looks like. A patient presents with documented symptoms clinically consistent with pulmonary embolism. The treating physician orders a chest X-ray, but does not order the D-dimer blood test, a diagnostic step required under the established standard of care for that precise presentation. The patient is discharged. The embolism is not identified. The patient suffers a fatal cardiac event within hours. The failure to order a test that the standard of care explicitly requires, given documented presenting symptoms, is a textbook breach. Clean causation, documentable damages, a valid case. Or consider this: a surgeon elects to proceed with an elective procedure knowing the patient consumed food within the required preoperative fasting window. The patient aspirates under general anesthesia. Aspiration pneumonia develops. The patient requires extended critical care and suffers permanent pulmonary damage. The decision to proceed with full knowledge of the fasting violation is a direct, documented deviation from established anesthesia protocol, with clear causation and quantifiable damages. These are the cases that attorneys take, not every adverse outcome, but every documented departure from an established protocol, under documented circumstances, with a direct causal chain to real and measurable harm. Please. The single most important thing you can do before any physician consultation where you have concerns, document everything. Every symptom you reported, every instruction you were given, every test that was ordered, and every test that was not. Because the standard of care test is a documentation battle as much as it is a medical one. The physician's records will be their primary defense. Your documentation, dates, conversations, instructions given, instructions ignored, becomes the foundation of the breach argument. Most patients lose malpractice cases not because the breach did not happen, but because they cannot reconstruct what the physician knew when they knew it, and what the standard required them to do with that knowledge. Documentation is not preparation for litigation. Documentation is the litigation. If you missed our last video on slip and fall, 4 evidence types that expire in 24 hours, the link is in the description below. Watch it after this one. This is your Decoded Advocate, and I will see you in the next one.